In this installment, Latisha Cohen is being interviewed by Christina Bezprosvanek on the topic of representations and warranties.
Hi, Latisha. I heard you have all the tea on representations and warranties, and I'm looking forward to learning more from you.
You know that I'm always happy to spill the real tea. Representations and warranties are vital components of commercial leasing and real estate agreements. They are mostly used to provide assurances to buyers and tenants about the property that is the subject of a transaction, but they can also be reciprocal.
What's the difference between a representation and a warranty? Do they mean the same thing?
Actually, they're not the same thing. A representation is an assertion of a fact. It is given by one party to another to induce the recipient to enter the contract. There is no ongoing performance aspect of a representation. What is critical about a representation is that if it is inaccurate, then we say that the party providing the representation made a misrepresentation. Contrast that with a warranty, which is a promise by a party that an asserted fact is true, and unless it states that it's only applicable to a certain date, it will live on as an ongoing promise. If the warranted fact is or becomes false at any point, that broken warranty is considered a breach of the contract. There is an implied promise to indemnify the recipient of the warranty from the consequences of that breach.
Can you offer some examples of representations and warranties?
Sure. Vendors or landlords may provide representations about the property's condition, such as the state of any defects. They may represent, for example, that the property complies with zoning bylaws or environmental laws.
If I'm purchasing a commercial real estate property, what kinds of representations and warranties might I need from the vendor?
Good question. You may want something as simple as confirmation of the vendor's corporate status and its authority to enter into the agreement, or something more significant, such as there are no encroachments or encumbrances on the property.
Got it. What might a tenant want by way of representation?
As a tenant, you may want the landlord to represent the condition of the physical aspects of the building, such as environmental contaminants, mechanical equipment, or they may want representations about restrictions impacting the use of the leased premises, such as exclusives in other tenants' leases prohibiting certain competitive business.
What happens if a representation or warranty turns out to be false?
That's a law school exam question. Well, the answer depends on whether it's a representation or a warranty and whether the party who made it knew it to be false. Liability for damages can arise, and other remedies, such as termination, will depend on the nature and severity of the incorrect representation or warranty.
How can parties be sure that they're making accurate representations and warranties?
Due diligence is key. Every purchaser or tenant should thoroughly inspect the property and ask for relevant documents. Vendors and landlords making representations should ensure that the information they provide is accurate, up-to-date, and complete.
Thanks, Latisha. That was informative, and it sounds like representations and warranties are fundamental to trust in a commercial leasing or real estate transaction.
That's right. And you're welcome, Christina. It is always a pleasure to rep the real estate law community.
I see what you did there.
That was Latisha Cohen in conversation with Christina Bezprosvanek on the topic of representations and warranties. If you would like to learn more, contact Latisha on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.